First case to come before us this morning is State of Ohio versus Geric, Courtney, Ellis. You will have 15 minutes to present oral argument. Please don't use the names of any victims or minors, as we are recording this and posting it on the court's YouTube channel. Judges have read your briefs. We're ready to see when you are.
Thank you, Connor. May it please report. My name is Brian Smith. I'm appearing on behalf of the appellant, Geric, Courtney, Ellis. Your Honors, I'd like to speak briefly to the restitution issue. This was a plain error issue with restitution because the court did not make the required findings on the record to impose restitution in this case. The statute states that the award has to be made at sentencing, quote, in open court. And that requirement was not met in this case. Because of this, there was also no competent, credible evidence in the record, particularly from the sentencing hearing, to support this, the finding of $4,200 in restitution. The PSI did not even contain this amount. This was an amount that was added in after the fact. It was made part of the trial court's sentencing entry, but not stated on the record.
It was an agreed amount, is that correct?
I'd have to double check, Your Honor. I don't believe there was an agreement necessarily as to the amount. There was that's why I believe there wasn't an amount stated.
So you agree, you would say there was an agreement he would pay restitution, but there was not a specific amount mentioned for the agreement?
I believe that's what happened. I'd have to double check that, but I don't believe there was a specific amount that was agreed to. And had there been an amount, that still should have been stated on the record at the sentencing entry, or at the sentencing hearing rather. And the problem with that too is there's also, the PSI actually contradicts the amount of restitution, at least to an extent, because it says that the vehicle and nearly all of the items from the victim's purse were recovered here. So there's also, there's actually evidentiary support, if anything, weighing against a finding of $4,200 in restitution. The court had to determine restitution to a reasonable degree of certainty. And the problem here is, again, there's no discussion in the record. It's more or less a silent record, really, as to the facts underlying the claim for restitution. And so the record, it was plain error in this case to award $4,200 in restitution because there was no evidentiary support placed on the record for awarding that amount. And it ultimately leads to prejudice because even though the appellant is incarcerated, he's indigent. I believe the PSI indicated he was unemployed. So he has this award of restitution that's out there that he's going to have to pay most likely when he's released, and that's going to be an additional economic hardship on him once he is released after serving the sentence. And that actually brings me to my next point, which was we don't know when his sentence is actually going to conclude because it was an indefinite sentence under Reagan-Tokes. Now I understand that the Ohio Supreme Court is still considering this issue on State v. Hacker. I believe as of yesterday it's still an open case. It was argued in January. However, we would submit that the Reagan-Tokes Act violates the separation of powers. It violates the due process clause under the federal and state constitutions, and it also violates the right to trial by jury. I believe the appellee had indicated that there's no constitutional issue because the current law doesn't indicate that it's unconstitutional. However, we would submit that the constitutional provision is part of that current law. So we would submit that it's a separation of powers issue, that it's still unconstitutional. And this court has rejected Reagan-Tokes challenges before, I believe in State v. Bennett and State v. Arthur. However, those cases were rejected because essentially it was an underdeveloped argument, that it was a plain error argument. However, it wasn't sufficient. I believe was indicated, especially in State v. Coleman, that the argument wasn't sufficiently advanced for the court to even consider it. So we would ask that this court consider those issues at this point, obviously mindful of the ongoing litigation in State v. Hacker that will most likely put the issue to rest one way or the other. But we would ask that the court consider those constitutional issues on Reagan Tokes as well.
And you're also, in this case, making a plain error argument, correct?
Yes.
You will not raise below by counsel?
Correct, yes, it was plain error on the restitution and on the Reagan Tokes issues. However, we would still submit that it meets that standard because of the statutory issues with the way the restitution was conducted, and with respect to Reagan Tokes on the constitutional issues that are inherent in both as applied and facially with respect to the indefinite sentencing statute. And I hope that answers your question. I'd be happy to take any further questions in my remaining time.
I guess, and I understand why, I guess the restitution is argued as a plain error argument. But this is a case where there was nothing discussed on the record, and then we have the sentencing error, the sentencing entry. So I'm wondering, is it plain error because where was the opportunity for Ellis to the appellant here to object? You know, I completely understand why it's being argued that way because there was no objection, but when would that have happened?
Well, and that's actually a great question, Your Honor. It's we argued it as plain error. However, again, since there was no restitution award that was made on the record, it's possible that it could be even be an abuse of discretion. It almost could be looked at as an abuse of discretion in this case because if there's no award of restitution made, there's nothing to object to at the sentencing hearing. So procedurally, it could potentially be an abuse of, we would ask the court to even consider it under even an abuse of discretion framework given that there was no opportunity to object at the sentencing hearing.
What about when the prosecutor announced that that was the amount? Because what you're arguing is that it wasn't announced by the judge in open court and there was no basis for the calculation, but wouldn't there be an opportunity to argue at the time the prosecutor asserts that's the restitution amount?
Yes, and that could potentially be as well, Your Honor, that I believe the prosecutor did mention it was $4,200. At that point, you could potentially argue that there would be an opportunity to object there, but again, there's no basis, there's nothing to back up the $4,200 figure. So this is a singular statement that's made saying restitution was $4,200. The state's counsel didn't put forth any evidence as to why that number was the case. There weren't any receipts, no medical bills, no statement as to the contents of the purse or any other evidence that was, or exhibits that were presented as far as supporting that amount. So we would submit that we argued it as plain error again, but we would submit there's at least an argument to look at it as abuse of discretion based on the fact that there's no underlying evidence that's presented for the $4,200 figure. So arguably, there's nothing specific to object to in that regard.
And the state agreed in its brief that there was error with the restitution, as I recall.
I don't believe they conceded that there was error with the restitution amount. I believe they conceded that they conceded that there was error with the procedure, but not the amount. So the state's arguing send it back to where the trial court could just say, this is why I'm ordering $4,200 in restitution. We would submit that the remedy is different, that it has to go back and the trial court has to have a new essentially have a new hearing on restitution, or at least allow the appellant to request a restitution hearing to determine what the basis is for the $4,200.
Would Do you agree with that, even if that's through a negotiated plea, that there's a $4,200 restitution amount as a negotiated plea in this case?
We would submit that there's at least a right to a restitution hearing here because there wasn't a specific amount indicated for restitution on the record, other than the state's counsel's own statement as to what that amount was. So, if the 4,200 was a stipulated amount, the state's counsel could have indicated that on the record and said, this is a condition of the plea. There was nothing on the record to indicate that specifically was part of the negotiation. Now, could there have been some sort of negotiation there could have been something off record indicating that. However, I don't believe that was indicated at the sentencing hearing. So we would submit that based on that it's still plain error to award restitution based on the fact that there was non-compliance with the statute at this point. And I'd be happy to take any further questions with my roughly 4 minutes remaining.
Seeing none, thank you, counsel.
Thank you, Your Honors.
Thank you very much for your presentation today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both parties by the clerk of courts, as well as it will be posted on the Ohio Supreme Court website.
Thank you.